entertaining my thoughts.
Thank you,
Representative Bridges. Could I address that for 1 minute, please?
Yes, sir. Please go ahead.
Yes, absolutely. The 1.5 million, that does sound like a lot of money. It's spread out over 6 years. The statute allows for $75,000, which is really just enough for an analyst, not really for over the period of 5 to 6 years like we're looking at. So there will need to be some sort of additional funds. But your point is well taken that we don't need so many different accounting systems. That's one of the reasons why this and the broadband development program are both well situated to be taken care of by KIA. There will be some overlap in the training that our staff has and in the computer systems that we have. Most likely, however, we will have to use IT staff to create proprietary software in order to track these funds properly. So there will be some more funds that will have to be used there. And also, I'd like to state that this money, we're talking now about the state law. The federal law does allow for the funds to be used for administrative expenses. And it's actually in their FAQ, it's addressed and it is allowed. So I'd just like the committee to be mindful of that, and also that the amendment that was passed, I believe, takes that out. Am I correct about that?
Sir, are you asking us that question?
Yes, sir. Yes, sir. The amendment you just passed, I didn't hear anyone read it, but what I was sent earlier was one that deletes that section from the proposed ordinance or regulation.
Well, there were parameters set in place by Senate Bill 36, and I haven't got that latest amendment, so I apologize for that. But my main concern is we've got $1.25 million, we've got $1.5 million, so we've got $2.75 million, and then I believe there's another $50 million that is on the table there with the KIA also that will be involved in this. So we're talking potentially $600 million, and there again, I promise you, I'm not trying to keep money from you that's needed, but I also want to make sure that we work efficiently in that. And when we're looking at a potential of $3 million, there's a lot that can be done with that. And if we got two similar programs, and I guess my urging is that we keep that in mind and just don't take the money because it's there, but get as much out to the communities as we can.
Anything else, Representative Bridges?
No, I'm finished. I appreciate you, Mr. Chair. And I appreciate KIA, your representatives and all that y'all do. And so this is, I promise this is not a negative comment. This is just urging that we do our due diligence. And I appreciate you guys for all you do. Thank you.
I think Senator West has a question.
Thank you, Mr. Chairman. I really appreciate Representative Bridges' line of questioning. One of the largest roles of this committee is not necessarily finding things deficient or asking people to defer, but it is getting information out to the general public, the citizenry. So my line of questioning is going to be along the same lines as Representative Bridges. I don't have a problem with there being money set aside to implement the program, but we do need good information. The first question is, how much money, according to HB or Senate Bill 36, how much money is in this pot? We have some confusion with, there's blending of programs. Just to make sure we're talking about the same pot of money.
Yes, thank you for that question. The Senate Bill 36 authorized or appropriated $250 million for water and sewer projects from the American Rescue Plan Act. I believe Representative Bridges mentioned the broadband deployment fund, which, while it was also authorized and funded through the American Rescue Plan Act. It is a separate and distinct program with a separate and distinct accounting structure, with the same accounting, using the same accounting backbone.
Thank you. Have you started taking applications on these projects?
Yes, sir. We have, I wish I had already had that pulled up. We have over 700 applications. I'm sorry, we have over 400 applications for more than $700 million.
That's what I thought. I thought there were already quite a few applications in, and this was going to be a tremendous impact to the KIA as far as workload, and I don't have a problem with that at all. One thing I do have a problem with is, part of the job. Another part of the job of this committee is to make sure that the law is carried out and we're using proper procedure and process. So I don't really find the statutory authority to implement these fees. In the statute, we specifically say $75,000, and reference was made to the federal law allows for collection of the fees, but the federal law is not cited in the regulation itself. So I really feel we might need, when we come back into session, we may need to take a serious look at this and make sure we have the proper authority. Can you answer that question? Do you feel that you have the proper authority under existing KRS to charge those fees? I'm assuming you do, or you wouldn't be here. But
Thank you for that question. We do believe that Senate Bill 36 did name the Coronavirus State and Local Fiscal Recovery Fund in the bill, and that Coronavirus State and Local Fiscal Recovery Fund was the fund established in the American Rescue Plan Act. And the American Rescue Plan Act does say that administrative fees are eligible. And I could refer you to the U.S. Treasury FAQs, and that's on U.S. Treasury's website. It's on page 38 in section 10.2 that does say recipients may use funds to cover the portion of payroll and benefits of employees corresponding to time spent on administrative work, and then goes on to cite those funds.
Would you agree to defer this regulation so that sorry, I didn't have my mic on. Would you agree to defer this regulation until you could add the federal statutory site for your authority?
Is it not in there?
We may be overlooking it. We don't see it in the reg. We'll check one more time.
I was looking at it quickly.
It's referenced. It's referenced in the state of emergency, but it's not in the reg itself. It's only KRSs.
If you believe that that is the appropriate manner in which to get the regulations passed correctly, we would agree to defer.
And once again, just for clarification, just like Representative Bridges, I'm not trying to stop the trains from moving, but we need to pay attention to detail, and I really think it would be best if we gave it the best chance. So that's my opinion. I'm only one on this committee, so that's all my questions.
Sir, if I may interject.
Yes, sir. Proceed, sir.
Thank you, sir. I'd like to point out that it does say in our reg that it's 1/2% as allowed by law. And it's well taken that we could absolutely cite that law and say it is the federal law. But what the federal law says is that it's for administrative fees. So we would be outside of that if we were to take any of this money and just put it in the general pool that KIA uses. So we are trying to act within the bounds of the federal law here. I'd also like to point out that this is the emergency reg. We can make that amendment to the actual regulation, which comes up for review next month.
Mr. Chair, this is
Yes, I'm
Senator
sorry. Go ahead, Senator.
Thank you. I know it's a little difficult with the Zoom, and I'm still fairly new to this committee, but just through in the abundance of caution, wouldn't you normally keep the language broad like that to say as allowed by law on an emergency reg, as opposed to going and pinpointing down, just to protect us? We're looking at being good fiduciary duties. Obviously, we want to discuss that and make sure that we hammer out those details, but in the actual language of a special reg, wouldn't that normally be the course of action? The lawyer in me is saying that might be the most prudent course anyway, but correct me if I'm wrong.
Well, sir, I'm not an attorney, so I'm kind of a little bit at odds, not at odds, but kind of listen to the attorneys in their comments back and forth. I think Senator West could probably comment on that specific question, Senator, better than I could.
Yeah, I think you're exactly right that it was good to word it that way and put it in language that way. What I'm not saying that the federal law doesn't allow it. What the federal law, according to what was stated, says is that you're allowed, if you want to collect these fees. Our statute, we can put in statute that you're not allowed to collect the fees if the federal regulation, federal statute gives us that leeway. And that's all I'm saying is, even though the federal guidelines allow it, and it's optional, according to our KRS we passed, it says 75,000 and does not mention it whatsoever. So I think as legislators, we have that ability to make that call. And I'm just trying to give this regulation the best chance of standing. So to answer your question, I think it's good that it's in there, but in some cases the state law will trump the optional federal laws in this case. So that's my opinion.
Senator Yates, you have anything else, sir?
No, I appreciate the discussion. I realize that obviously the federal law, we're going to be preempted, and that kind of sets the baseline, and we can legislate above and beyond that. And so I think that we said that allowable by law is kind of a save all, but I do understand that the need, if we want to further legislate within those parameters, that we have the right to do so. And again, I still try to tread lightly as a freshman senator, kind of looking through there. If it increases the chances by making sure that we clearly articulate those parameters, then by all means. I guess just if I was just doing a contract review, I would think that probably wouldn't be necessary. But again, I appreciate the discussion.
Ms. Williams, Mr. Pauly, the question actually was presented, would you be willing to defer this? In just the question, I guess, would you be willing to do that, or is that something that you would not feel comfortable at doing at this particular time?
Bill Pauly did bring up a really good point, that this is the emergency reg, and we will be back before you next month with our ordinary regulation. If we could continue with our emergency regulation today with the committee's support, we would like to do that. It will help us to start evaluating the over 400 applications that we have looking at currently, and that represents 111 of our 120 counties. So not even all of the counties have their applications in the system yet. So if if we could have the committee's support for our emergency regulation and to take your comments into consideration for our for your review for our regulation next month, we would like to do that, please.
And I certainly appreciate that very much, and thank you for that answer right there. Senator West does have a comment, and then I think Representative Marzian has a question she'd like to ask. Senator West.
I would just say, for the record, I'm perfectly okay with that. That sounds logical. We'll get, with the emergency reg and the ordinary, we'll get 2 bites at the apple. So the Commonwealth won't come to a standstill in the next 60 days on this issue. So I'm perfectly fine with that.
Representative Marzian.
I just wanted to say I agree with the senator, and this will land in another committee prior to, so if there is something that's standing out, maybe we could address it at that point. So I'd say move it on.
So having said or heard those comments, we do appreciate your testimony today. Is there anything else you'd like to add? And we have decided that we are going to let this move on through the emergency reg process.
I just thank the committee for having us today and look forward to your action.
Thank you very much. There being no further questions from any of the members, please call the next regulation.
Boards and Commissions, Board of Pharmacy, 201 KAR 2, 270, 360, and 420, all 3 with staff suggested amendments.
2012-270 is being amended to update the requirements and criteria for minor violations and the procedures for expungement. 2360 is being amended to authorize the pharmacist to dispense naloxone to any person or agency for administration to the public as part of a harm reduction program, and remove the educational requirement for pharmacist certification to dispense naloxone. 2420 establishes the requirements for pharmacists, pharmacist interns, and pharmacy technicians to administer vaccinations. The staff suggested amendments to these regulations amends various sections to comply with the drafting and formatting requirements of KRS Chapter 13A and make technical changes.
Would you please identify yourself today for the record, whoever's joining us, please?
This is Eden Davis, General Counsel for the Board of Pharmacy.
Is there anyone else? Thank you, Ms. Davis. We appreciate your time today. There are staff amendments. Is there a motion for approval of the staff amendments? There is a motion. Is there a second? There is a motion and a second. Without objection, there is a question from Senator Alvarado. Go ahead, Senator Alvarado.
Thank you, Mr. Chairman. Just really briefly on Section 4, the one thing I understand the education of our pharmacists and that sort of thing, but people that are receiving naloxone to administer naloxone, number 5, which is the information on naloxone, is there a reason why all that information is being stricken? I mean, everybody presumes that naloxone has got no potential risk, but there are risks with administration. I know I just went recently to a group from the University of Kentucky. They were presenting information on Narcan, handing out samples of this to people, and I listened to their presentation where they covered all this material as part of their presentation. But one of them is that it can cause pulmonary edema in people, and I think the folks that administer it should at least know that risk. So I understand this, sometimes you want to just be, if someone's knocked out, you don't want to delay and have to go through a lot of that processing, but is there a reason why that information about the drug, what can happen from it?
So I think the rationale of the board in making that determination was that we received a big push from CHFS and those that were working to dispense naloxone to agencies, that there needed to be more access to the dispensing side of it. And so the remedy that the board conceived was that if we were able to remove the education, currently a pharmacist, in order to be certified to dispense naloxone, had to fill out the application and also have all of these educational training requirements. What has been acknowledged is because it is this extra application process that requires all this extra material, there are simply not enough pharmacists out there that are willing to do the certification. And so the thought is that pharmacists are professionals. They are going to, if they choose to certify themselves to dispense naloxone, they are going to know how to do it. They are going to know the risks. This is just trusting that the pharmacists will do that on their own, rather than the board supervising that educational training component.
And I appreciate that. That's regarding Section 5. I'm referring to Section 4, which is the education to be provided to persons receiving an naloxone prescription under protocol. So I trust the pharmacists, and they're dispensing it to someone, but just the information that needs to be conveyed to that individual. So if you're going to a layperson saying, here's some Narcan, here's how to administer it, to say there's going to be some written education material, maybe just show how it's being administered, and that's it. The question I've got is there's side effects from using a drug. So if we're letting lay people have that drug, administer it, there's risks to that. We're taking out the requirements to inform that individual of the risks of those drugs, of what to watch for. And that's what I understand Section 5 about educating our pharmacists. I don't question that at all. I just question the information should be conveyed to lay people who will be administering this drug, and we've stricken all that language out of it, and I'm wondering for the reasoning behind that.
Yeah. I'm sorry for misunderstanding your question. I think the reasoning behind that was because pharmacists are always, anytime they're dispensing any type of drug, they're given the patient is always given the opportunity for counseling. And so there are times when an individual simply doesn't wish to have that counseling. And this is with any drug, not just naloxone. And so that offer will always be made. And of course, if the individual is wanting to have that information, then at that point, the pharmacist would provide them with all of this information, if not more, and answer any questions that they might have.
If I could, yeah, but
yes, please go ahead.
It's one thing if you're administering a medication to a patient who's taking it themselves. This is being distributed to people who will be administering it to someone else. So it's one thing if you're getting a blood pressure medicine and the pharmacist says, okay, this is the blood pressure medication. You will be taking it daily. Here's how you take it. Here are the risks. Here's how you take it. Any questions that you have. This is somebody, you're giving it to someone else. Part of the protocol is to give it to someone who might have family who requests Narcan to be given, so someone can take that, and they'll be administering it to someone else, not to themselves. And so that's why that person might say, great, I just need some. I've got a kid who has a problem, or I'm fearful of someone else having it. You're not administering it to yourself with risks of that. You're administering it to somebody else. And so that's my worry, is that there's a lot of language in there of saying what are the risk factors of opioid overdose, the strategies to prevent them, the signs of opioid overdose, steps in responding to an overdose, information on the drug itself, and there's risk factors of administering those drugs, procedures on how to administer it proper storage. That's for you're giving that to somebody else who will be administering it to another person. And so we're striking all that. That's all safety language of what this drug can do. So I think the average layperson doesn't know, hey, if I give this to somebody and I thought they were overdosing, but they really weren't, and I give it to them, and now they're short of breath and having pulmonary edema, what should I do? All that safety information has been stricken from that. That's my concern. That's the only area that I'm worried about. I'm not sure the reasoning behind it. That's why I was asking.
Would you like to respond, ma'am?
I believe our executive director is currently on. Mr. Larry has comments regarding that concern.
Thank you all for the opportunity to speak, and I apologize I wasn't on earlier. I was detained and could not appear. But
sir, could you please identify yourself for the record, please?
I'm sorry.
Go right ahead.
I'm Larry Hadley, Executive Director of the Kentucky Board of Pharmacy.
Yes, sir.
And,
now go ahead, proceed, and if you'd like to respond to Senator Alvarado's comments.
Yes. And the question, as I understand it, was patient information or information provided to the person who is administering, and a concern about side effects. And Senator Alvarado, if I haven't characterized that correctly, please let me know.
No, that's correct.
Okay. The information given to the person administering is basically how to administer and what to look for and those kinds of things as far as when to administer. It is typically an emergency situation, and so this person who is administering is typically a lay person who has never used a syringe before. And so the side effects, you know, at that emergency time are, you know, not the crucial factor. The crucial factor is to get the Narcan into the person who is in overdose. Does that help? Does that answer your question, sir?
No, and I don't want to belabor the point, Mr. Chairman. I know you have a lot of things to go through, but obviously when you're administering it, you're not going to be breaking open the pamphlet. That's why you're having this educational moment when you give this drug out to somebody. So someone comes in and says, I want to give it intranasally. Okay, here's how you give it. Here's the education. Here's some information on it to explain a lot of the information about the drug risk. So you have that conversation. That person receives that information. Then when the moment of emergency comes, they're already aware of it. They're already educated on the topic. We have purposely removed a lot of those sections of what needs to be in this pamphlet. So, and the educational material, which could change. So right now it has that information in there. By removing all this information out, they say, well, we don't have to explain any of it. Just give it to somebody. Here's how you give it. Don't worry about the rest. That's where I have the bit of the issue, because administering, if it was just no big deal, there are big deals to giving Narcan. There are risks to giving Narcan. And so the purpose of doing this is you give it to someone ahead of time, inform them of the risks so that they're aware then. Then when the moment comes, they can give it. They know how to give it. But there's also potential risks of it that they can watch for. And so by removing all this language out, it's like we're almost saying that doesn't matter. It isn't really, all that matters is how to give it. Don't worry about the rest. That's my concern and worry, is that this is a safety factor, a section that was included in here, that these signs of all these things should be in the educational material when that person's receiving that drug. The moment of emergency comes later. It isn't the time that you're educating that individual. So I would have liked to have seen a lot of that information to remain in, is to require that to be part of the educational for someone who's a layperson who doesn't have any medical training and doesn't know what naloxone is and how it works and what problems can come from administering it.
I fully appreciate your concerns, and we'll be happy to take it back and rework that language.
Thank you, sir.
Thank you.
Any other questions? There being no further questions, before we move to the next regulation, I just want to point out to any of the members that are joining us remotely, I know we may have a hard time communicating, but you'll just have to interrupt and I'll recognize you if you have a question. Just speak up and let us know here. We don't want to miss anybody that has a question on anything. So please move to the next regulation at this time.
Board of Medical Licensure, 201 KAR 9270.
This administrative regulation is amended to include physician assistants, so they are held to the same professional standards when prescribing or administering buprenorphine products. The staff amendment amends various sections to comply with the 13A drafting requirements.
Good afternoon. Would you please both identify yourself today for the record? Is your mic? Yeah.
My name is Mike Rodman. I'm the Executive Director of the Kentucky Board of Medical Licensure.
And I'm Leanne Diakoff, General Counsel for the Board.
Again, thank you both for being with us this afternoon. There is a staff amendment to this regulation. Is there a motion for approval of this staff amendment? There has been a motion. Is there a second? The motion has been made in second. Without objection, it is so ordered. Are there any questions for either of the panelists that are before us today? It appears there are no questions, so we thank you all for your time today. Please call the next regulation at this time.
Board of Embalmers and Funeral Directors, 201 KAR 15040 Emergency, 050 Emergency, 110 Emergency, and 125 Emergencies. These do not have additional staff-suggested amendments.
201-15040 is being amended to change the schedule for licensure examinations and make clarifications. 15050 and 15110 are being amended to refer to the fees established in 201 KR 15030. 15125 is being amended to change the timing of the exam and payment of the exam fee and refer to the fees established in 201 KR 15030.
Good afternoon. Would you please identify yourself today? Christy, is the green light there on? Oh, okay. Thank you. Thank you, Christy, for being with us today. There are no amendments to the specific regulations that was mentioned. Are there any questions from any of the members of the subcommittee today? It appears there are no questions, so we thank you for your time today. Please call the next regulation.
Tourism, Arts, and Heritage Cabinet, Department of Fish and Wildlife. 301 KAR 1, 012, 16, 18, 19, 31, 50, 82, 120, 125, 140, 152, all with staff suggested amendments. 210, 215 with staff suggested amendments. 2041, 2050 with staff suggested amendment. 2084, 2111, 230 with staff suggested amendment, and 260 with staff suggested amendment.
301, 1012 is being amended to insert an additional exception to the general prohibition on swimming. 1016 is being amended to change the term grandfathered to the term exempted in the definition of existing structure. 1018 is being amended to expand the definition of camping. 1019 is being amended to refer to 301 KAR 1015. 1031, 1050, 1082, and 1120 are being amended to remove redundant language, update provisions, and clarify various sections. 1125 and 1140 are being amended to add hearing requirements for denial or revocation of a permit, clarify provisions, and clarify various sections. 1152 is being amended to update and clarify definitions, add language to prevent harvest of row-bearing species, expand the type of net sets allowed, update call-in requirements of program participants, update harvest submission timelines, require program participants to mark the end of their nets with floating buoys, require participants to harvest, possess, and transport fish claimed under this program separately from fish harvested by any other method, remove distancing and occupancy wording as it applies to multiple program participants when on the water, add language to allow program participants to fish in waters open to commercial fishing, add language to allow the department to restrict fishing in locations where there would be excessive user conflict, add requirements for unlicensed helpers, add requirements for suspension of a commercial fishing license, and make clarifications. 1210 is being amended to update provisions. The staff suggested amendments to these regulations amends various sections to comply with the drafting requirements of KRS Chapter 13A, correct statutory citations, add a statutory citation, and make technical changes.
And I'm going to interrupt the description real quick and clarify that 301 KAR 2015, the feeding of wildlife, was deferred immediately before the agenda. So
301 KAR 2041 through 2260, amend to clarify provisions and correct citations in the agency address. The staff suggested amendment amends various sections to comply with the drafting and formatting requirements of KRS Chapter 13A.
All right. We welcome back today Fish and Wildlife with 4 pages of regulations. Who is joining us today? And please identify yourself.
Rich Storm, Commissioner.
Dave Dreves, Acting Director, Fisheries Division.
Chris Garland, Wildlife Division Director.
Steve Fields, Staff Attorney.
All right. Thank you, gentlemen. Thank you, Commissioner, for being with us today. Mr. Garland, Mr. Dreves, Mr. Fields, we appreciate your time today. A lot of regulations that have been brought before our committee this afternoon. There are staff amendments to these. Is there a motion for approval of the staff amendments? There has been a motion and there is a second. Without objection, it is so ordered. Do any of the members have any questions for any of our folks from Fish and Wildlife today? Senator Alvarado, you do not have a question on frog season?
No, sir, I do not.
Okay. I thought you might be interested in that specific regulation there, but I do have one quick question, if I might, please. This would probably go to Fisheries Director Dreves on 301 KAR 001140. It's referring to the special commercial fishing permit for Kentucky and Barkley Lakes. Could you explain to me just real quickly what that specifically involves or what that's about? Or whomever would like to address that.
I believe you're still muted.
Sorry about that. The special commercial fishing permit for Kentucky and Berkeley Lakes has to do with the fishing for roe-bearing species, among others, paddlefish and the like.
So what do they have to do to apply for that license? Is there something they have to do specifically to get that permit?
They have to apply, but it says that in the regulation specifies that the department shall not issue more than 25 permits. And they must submit an application to the department before November 1st.
Do you have that many that apply?
I don't believe that we have that many apply, but I'm not certain about that answer, Mr. Chairman.
And then one other question, if I might ask, could you just give, just for maybe this committee, or maybe this is just for me personally, on the harvest and the sale of the Asian carp, how's that proceeding?
It's going well. We continue to have a large contingent of commercial fishermen that are harvesting Asian carp in Kentucky and Berkeley Lakes, and we're up to over 9 million pounds harvested so far this year.
Are they being able to, once those are harvested, are they being able to store those before the shipment of those? And is there facilities that are allowing them to do that? A lot of fish are going to fish meal, and that doesn't require much storage. We do have a couple of processors that do have capability to store fish that are processed for both human consumption and for bait markets in other areas of the country. All right. Thank you, sir. I appreciate that. Any other questions from any of the members? Commissioner Storm, thank you for joining us on today. Appreciate that very much.
Thank you. Thank you for having us.
Please call the next regulation at this time.
Transportation Cabinet, Department of Vehicle Regulation, Motor Vehicle Commission, 605 KAR 1030, 035, and 215, all with staff suggested amendments.
605-1030 is being amended to remove various sections because the provisions of those sections will be promulgated in a new regulation. Modify, add, and renumber various sections to eliminate unnecessary language, clarify that licensee names must be unique, and provide that the Commission may request additional information, include language to clarify that members and managers of limited liability companies may be required to make disclosures and provide information to the Commission, establish that a minimum net worth of $50,000 in encumbered cash and unencumbered inventory is considered the minimum amount required to demonstrate financial fitness of the licensee, address that the bonding requirements set forth in KRS 190-030 will apply to applicants with a net worth between $50,000 and $100,000, reflect that the Revenue Cabinet is now the Department of Revenue, and make technical changes. 1035 establishes facilities requirements for motor vehicle dealers. 1215 establishes fees for motor vehicle dealers, manufacturers, and other entities regulated by the Motor Vehicle Commission, and establishes renewal timelines and procedures. The staff suggested amendments to these regulations amends various sections to comply with the drafting and formatting requirements of KRS Chapter 13A, add a material incorporated by reference section, and make technical changes.
Good afternoon. Gentlemen, please identify yourself for the record today, if you don't mind. Sir, is your green light on?
Yes. I'm Curtis Cassidy, Executive Director of the Kentucky Motor Vehicle Commission.
Thank you. Please.
My name is Trevor Earl. I'm counsel for the commission.
Thank you, gentlemen, for being with us today. We appreciate your time. There are staff amendments to the regulations that was given to us. Is there a motion for approval? There is a motion. Is there a second? There is a motion and a second. Without objection, it is so ordered. Do we have any questions today from any of the members of our subcommittee? Senator West has a question. Go right ahead, Senator West.
Thank you, Mr. Chairman. Walk us through 605 KAR 001215. You got the Motor Vehicle Commission, and it's in the summary, it establishes fees for motor vehicle dealers. Staff tells me this is a new regulation. Does this replace an existing reg, or what are the new fees, and how did we get here to those fees?
I can answer that. The statute KRS 190030 changed this year in order to eliminate the statutory fees for motor vehicle dealers and change that to provide that the fees would be set by the commission. The statutory fees had been in place since the early 80s and had never changed. I'm not aware of why the statute moved it to the regulation other than probably to avoid necessary changes over time. But the fees that are in place mirror the statutory fees, but they are an increase.
Do you, many times as legislators, after we vote on something, we forget the number. So is this, what Senate bill or House bill was this tied to? What number? Do you know?
Yeah, I should know that off the top of my head.
Don't worry, it's easy for...
It's referenced in the emergency regulation that was promulgated earlier. And I can provide that to the committee if we need.
Thank you.
Are there any other questions? There being no other questions, thank you, gentlemen, this afternoon. Please call the next regulation at this time.
Education and Workforce Development Cabinet, Board of Education, 704 KAR 7121 and 707 KAR 1340. 340 has a staff suggested amendment.
704 KAR 7121, repeal 704 KAR 7120, home and hospital instruction, as these provisions are being repromulgated in another regulation. 707 KAR 1340 amends to clarify the difference between an admissions and release committee or ARC meeting notice to parents and prior written notice provided to parents, including the requirements for notice content and timeframes. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself today for the record at this time?
Good afternoon, Todd Allen, General Counsel for the State Board of Education and Department of Education.
Good afternoon, Greta Hilton, Associate Commissioner of the Office of Special Education and Early Learning in the Department of Education.
Anyone else? All right, thank you, Mr. Allen. Ms. Hilton, thank you all for your time today. There is a staff amendment to this regulation. Is there a motion for approval?
Co-Chair Hale, if I may.
Yes.
This is Todd Allen with the agency again. I would propose, if the subcommittee is willing, to defer 704 KAR 7121. That's the repeal of another regulation. There's a companion that goes along with that received a comment during the public comment period, and it will come back to ours next month. So I would propose that we defer 704 KAR 7121 to next month to keep both of those on the same timeline.
Is there any comments from anybody on that? We have no problem with that, sir. Thank you very much.
Thank you.
Okay, first off, let me finish up, Representative Marzian. We do have some staff amendments, and I don't know if I did this or not, but I'm following through there. Do we have a motion for approval of that?
So moved.
And there is a motion and a second without objection. Now, Representative Marzian, do you have a question, please?
Well, I guess I want to clarify. So KAR 001340 did go through, but the other one is deferred.
Yes.
Correct?
Yes, ma'am.
Okay.
Yes, ma'am.
Just checking for clarity.
Yes.
Okay.
KR 07121 was deferred. Any other questions? There appearing to be no other questions. Thank you all. Please call the next regulation at this time.
Labor Cabinet, Department of Workers Claims, 803, KAR 25, 165, 170, 175, 185, and 190. The first four have staff suggested amendments. 190 has been deferred. However, we are going to open it for discussion purposes only this afternoon.
803, 25, 170, 175, and 185 amend provisions for filing claims and other information with the department. Amendments include updating definitions requiring an online database of approved vendors for electronic data exchange, updating filing procedures commensurate with departmental changes, and revising conditions for the commissioner to notify email subscribers. 803, 25, 165 establishes requirements for electronic data interchange for vendor approval, definitions, application and qualification criteria, standards for the application process, standards for certification of a vendor, standards for the revocation of certification, and the electronic data interchange vendor application. The amended after comments version added a definition for applicant, revised the definition for vendor, reduced from 10 to 8 the minimum number of insurers for which an applicant shall submit data, clarified vendor revocation of certification provisions, and updated material incorporated by reference. The staff suggested amendment amends various sections to comply with KRS Chapter 13A. 803-25-190 is for discussion only.
All right, thank you very much. Would you please identify yourself today for the record, for whoever is from the cabinet?
Robert Walker, Interim Commissioner for the Department of Workers' Claims.
Sam Flynn, General Counsel for the Labor Cabinet.
John Galian, General Counsel for the Department of Workers' Claims.
Dale Hamlin, the Assistant General Counsel for the Department.
Anyone else?
Ed O'Daniel for the American Property Casualty Insurance Association.
Yes, sir, Mr. O'Daniel. We are going to proceed with the cabinet first, and then we will come to you, sir, okay?
Thank you, sir.
All right, thank you very much. There are staff amendments for the regulations. There is one of these that is going to be deferred, and we're going to just have discussion only, but for the other ones, there are staff amendments. Is there a motion for approval? There is a motion. Is there a second? And there is a second. Without objection, it is so ordered. Are there any questions on the specific regulations that are moving forward? All right, there appears to be no questions or comments from anybody of the subcommittee on those regulations. Now we will move to 803 KAR 025 190, and this one is going to be, this has actually been deferred by the cabinet, or they've asked for a deferral, but we are going to have discussion only on this. Would whoever from the cabinet would like to go ahead and proceed if you'd like to comment?
Yes, Mr. Chairman, it's Robert Walker.
Yes, sir, Mr. Walker, go right ahead.
And I can give you a brief overview and discussion of what this reg does.
Yes, sir, please do at this time.
But first, let me thank Senator West for taking the time to meet with Secretary Link, Mr. Flynn, and myself, and others from the Labor Cabinet last week to discuss this regulation. I know especially last week was a very busy time for all members of the General Assembly, but we do appreciate the time and him speaking with us. 803 KR 25-190's most important change is to add the position of medical director to the Department of Workers' Claims. Before we get into the regulation, I think it's important to discuss some of the earlier relevant legislation that was passed by this General Assembly. 2018, the General Assembly required the Department of Workers' Claims to develop and adopt a uniform treatment guidelines and a pharmacy formulary. Both good ideas that were designed to speed the delivery of medical benefits to injured workers. Both the treatment guidelines and the pharmacy formulary has been enacted. This is important because during the enactment of these measures, discussion began about the need for a medical director in Kentucky. It was discovered that a medical director would complement the treatment guidelines and pharmacy fee schedule. The department looked at other states such as Tennessee and Ohio. Both have medical directors along with treatment guidelines and pharmacy formularies. In fact, when drafting the current regulation in front of you today, we used Tennessee's plan as a blueprint for our plan. And as a result, the medical director proposed today or next meeting has almost identical duties as the Tennessee's medical director. Other states have medical directors such as Texas, Colorado. Georgia is even looking to adding a medical director to its system. I tell you all this because this is nothing novel or new. Medical directors are becoming more the norm in the workers' compensation world. Now, what this regulation does. First, the medical director must be a Kentucky licensed physician in good standing with the Kentucky Medical Licensure Board. The medical director has two functions: one, an advisory role, and two, conduct utilization review appeals. The advisory role provides that at least annually, the medical director will review and advise the commissioner and the secretary on the effectiveness of the medical fee schedule, treatment guidelines, pharmaceutical formulary, all in an attempt in reducing costs and speeding the delivery of medical services to injured workers. The medical director shall chair a workers' compensation advisory committee. The Workers' Compensation Medical Advisory Committee will have members from several medical specialties, members from labor, employers, employees, insurers, and self-insureds. And the committee will at least annually report to the secretary and to the commissioner concerning the activity, effectiveness, and impact of the medical director and the utilization review programs on the delivery, again, of payment of medical services to injured workers. The other duty is to handle UR appeals. UR means utilization review. That generally occurs when an injured worker seeks medical treatment. Now, this is when there is no dispute that the person has been injured on the job. The only dispute is the treatment reasonable and necessary? An example is if a worker injures his neck and the treating physician recommends surgery, the insurance company or self-insured employer will send the request for surgery to a physician of their own choice for an opinion on reasonableness and necessary. In our case here, is the surgery warranted? If the insurance physician disagrees with the treating physician, the treatment's not approved. Under the current regulation, the injured worker can ask for reconsideration, and the issue would be sent to another physician chosen by the insurance company. Most of the time, the new insurance physician denies the treatment again. The injured worker would then have to initiate a claim with the Department of Workers' Claims to attempt to get it approved. Matter must be assigned to an ALJ either as an interlocutory matter or as a normal filing. The injured worker may not get the treatment approved for several months. The proposed regulation here substitutes the medical director for the reconsideration process. It does not add another layer of appeal, but merely allows a direct appeal to the medical director after the first denial. So within days of the additional denial, the injured worker could have an employee of the DWC with medical expertise looking at the denial. There's no need to file a claim or seek interlocutory relief, and depending on what information is needed, the medical director can have a decision to the injured worker within 1 to 4 weeks, much quicker than our current system. Not only is it quicker, but this regulation places medical decisions right where they should be, in front of a medical expert. The current system forces an ALJ who has legal training and not medical training to make those decisions. As commissioner, I've been approached by current ALJs to support the medical director regulation because it relieves the ALJ of making this purely medical decision. The DWC has been working on this regulation for over a year. This project started in the leadership of former Commissioner Bob Swisher. Bob, Mr. Hamlin, and myself have put many hours into this regulation to make it something that will help Kentucky injured workers and be fair to all stakeholders. We have engaged members of the Kentucky Workers' Compensation Bar, both sides, plaintiff and defendant. We have discussed this regulation with medical providers. We have listened to employers and insurance companies, oftentimes changing the regulation to accommodate those requests. In summary, this is a good regulation. It will get medical treatment to injured workers faster and get them back to work faster. When employers get back to work faster, the employees win, the employers win, the insurance companies win, everybody wins. And thank you.
Thank you, sir. Thank you. Would anyone else like to speak from the cabinet? I think we do have some questions, and I will allow Senator West to give ask the first question. Then we have some others to follow.
Thank you, Mr. Chairman. First of all, I'd like to thank the cabinet. First of all, for agreeing to defer and listen to further discussion on this issue. This is a big issue. This isn't. This is a big deal, and I think we need to measure twice and cut once for sure. My first question would be, with the appointment of a medical director, what existing workers' comp problem are we attempting to solve with this regulation? My understanding in conversations with the plaintiff's bar and the defense bar is there are issues, but everything seems to be working fairly well. What specific issues are we attempting to address here?
And thank you, Senator West, for that question. We're attempting to speed up medical delivery of medical benefits to injured workers. I practiced workers' compensation for over 20 years, mostly representing plaintiffs. And I can tell you that one of the main concerns of mine was when I couldn't get a injured worker medical treatment quick enough. Now, remember, this does not involve if it's work-related or not. This will only come into play when we all agree that it's work-related. It's just a matter of, is this specific treatment warranted? And I submit to you that the system now may delay it to 3 to 4 to 6 months. The system we have that we propose under the medical director, we can actually get a medical expert to review a claim within 1 to 3 weeks, which will speed up the process. Also, I think this will help individuals that are not represented by counsel. A lot of times, workers that are injured on the job don't seek counsel. They don't know how to do the reconsideration process. One of the provisions in the medical director regulation is that the medical director actually reaches out to the injured worker and says to them, I can review this for you if you'd like. And so I think it also protects and helps injured workers that do not have counsel at this time. I hope that answers your question.
Yeah, it does. And once again, I appreciate you agreeing to defer. And as I stated earlier in another regulation we were covering, one of the great things we do here in this committee is get information out there. And this is what we're doing today. This is not an easy issue. You have to really think about it. So you cited an existing problem with the system as a delay in benefits. What is the cause of that delay? Is that due to a lack of ALJ judges? Could it be that the courts have been closed, a COVID issue? Is there something else we can do before we hire a new medical director and create a whole new bureaucracy within the cabinet?
Right. Again, thank you for that question. No, I don't think it's a recent problem. It's been a problem that I have experienced over my 20 years as a workers' comp practitioner. what usually happens in the old regulation is it goes to two doctors that were chosen by the insurance company. The insurance company has control of the process. So if they're denied both times by the insurance company doctors, the only recourse they have is to go to an ALJ. And that takes time to get in front of an ALJ. That takes time to bifurcate the issue so the judge can hear just the treatment concerns. What we've done is we really haven't added another layer of bureaucracy. What we've done is taken that second step, the reconsideration process that's happening now, and we replaced it with the medical director. So we're not creating or adding an additional step. We believe that the medical director, who will be independent, an employee of the Department of Workers' Claims, is in a better position to make that decision more quickly. So we're not, I know we're hiring a medical director, but we're not adding an additional step, if that makes sense.
And Senator West, this is Sam Flynn, the General Counsel for the Labor Cabinet, and I just wanted to piggyback on what the commissioner has just testified to. We're not actually adding a layer of bureaucracy. We're removing a layer of bureaucracy, and we're also reducing the amount of litigation that's associated with UR and going to the ALJ. So this is actually going to shorten the length of time it takes for injured workers to get benefits and also get back to work.
Thank you. That's all the questions I have this time.
Thank you, Senator West. Just a quick comment, and then we have a question from Senator Alvarado. I think all of us on this committee and all legislators, there's many times that we receive emails, calls, questions on these specific issues, and it can become very frustrating for our constituents that they face long delays, and I may not exactly fully comprehend exactly what this regulation is attempting to do, but from what I understand, it does appear that your goal is to definitely speed up the process and get them in front of someone or get them the opportunity. And I like the comment that you made that the medical director would be specifically reaching out to them. Do you just have a quick comment or response to that?
No, that's exactly right, and that was purposely put into the regulation so that we can get to more injured workers that are unrepresented by counsel that may not know the system. So if they get a call from the medical director's office saying, "I know your treatment got denied, but I can look at that for you," I think that is a huge benefit, especially to the unrepresented injured workers.
Senator Alvarado.
Thank you, Mr. Chairman. Just one question, a question and a comment. So in the current process, you go through two physicians to review this, then you're able to go to an administrative law judge who you're saying doesn't have any expertise in the medical field making a decision. After that, does the individual have any rights to go to the courts?
Yes, after the medical director?
No, after the ALJ under the current process. If they go to an ALJ and they don't get the result they want, can they go to the courts?
Absolutely. They go to what we call the Workers' Compensation Board first, and then from the board, they go directly to the Court of Appeals and then to the Supreme Court.
Very good. So this sounds like a medical review panel of one, is what it sounds like to me, which obviously I was all for that, and it was something that we filed here in Kentucky. And with all the same arguments you're making, sir, are the same arguments I made, that we could expedite it by having medical experts who can review a case, determine the legitimacy of something, get people an award more quickly. All these comments you're making were the exact same arguments made for medical review panels, which were then found to be unconstitutional by the Supreme Court here in Kentucky. So this goes forward and someone says, hey, this is a delay for me to be able to get to the courts at the end of the entire process because you've injected a medical review panel of one to review this case. Now I'm going to be required, have to spend more time waiting for this when I can go to the courts. What would be your argument against that if someone comes out? Because I would imagine if the Bar Association, if someone says, hey, I can't get to the courts as quickly, that was the argument against medical review panels for us when it came to issues in the state. And our Supreme Court 7-0 said, nope, it's unconstitutional. I don't see how this can be any different.
Senator Alvarado, thank you for that question. And I would have proposed that actually you get to the courts quicker this way.
I argued this. Yeah, I appreciate it. And I argued the same thing, and the Supreme Court disagreed, because that would be the same thing. You can get a judgment for someone who maybe couldn't find an attorney to take a case and could press an issue sooner. That was argued. We said, hey, look, it takes you 6 to 8, 10 years to get to a court to have to argue a medical malpractice case. That could have been done sooner through this because you get judgments. That's been proven. And the courts determined that, no, this gets in the way of that person being able to get to the court. So all these same arguments, maybe you're right. I argued the same thing on one angle, but our Supreme Court has already issued a judgment on this. And that's why I'm wondering is when someone comes in and determines this is illegal, I think that's a legitimate issue since our Supreme Court has already issued a judgment on it.
Well, instead of having another insurance doctor review it, we're having the medical director review it. Now, the aggrieved party can appeal it to an ALJ. So it does not end with the medical director. So if they feel the medical director is wrong, they can appeal it to an ALJ. They feel the ALJ is incorrect, they can appeal it to the Workers' Compensation Board, and then the Court of Appeals, and then Supreme Court. So it really is no different than what we have now, except that we're removing the reconsideration process that the insurance companies control, and we're interjecting an independent workers' comp employee with medical expertise.
And I understand that was exactly the same arguments. And believe me, sir, it was a bill that I worked on very hard for years. And that was the exact same arguments. No different. The person doesn't they can keep going through the court system. We said they had a time limit for a medical review panel to review a case and provide some independent panel of doctors to take a look and find if they think that something was done improperly because they had more expertise in the matter. And if the person found that something was improper, they can get a judgment much quicker. That's been shown across the country where these panels have been established. So your arguments are the same arguments I made and that were made before our Supreme Court and found to be unconstitutional. And that becomes a concern because we've already had a judgment. This is basically a medical review panel of one. Your arguments are the ones I have made. So my concern is the legality of this and that it would actually be unconstitutional in front of the Supreme Court. Thank you, Mr. Chairman.
I'm sorry, if I may, this is Dale Hamlin, the Assistant General Counsel. One of the things that may be different is that in workers' compensation, an employee is automatically entitled to the medical treatment if they're injured at work. So it's not really a matter of are they entitled to some treatment. That's a separate issue. In other words, if the injury was work related, that's a separate question that you can immediately take to an ALJ. The question before the medical director is simply whether the proposed treatment that the employee is already entitled to if the injury occurred at work, whether that treatment is appropriate. So it may be a slightly different question than the one you were raising before the Supreme Court. I don't know if that's the case or not, but perhaps it is. That may set workers' compensation apart just a little differently from what you were arguing.
I would argue that it is no different. It's just a different, the thing is, am I entitled to you could have somebody agree that something could have been done. Should it be higher or a smaller amount? It's no different of an argument. But the problem with the Supreme Court was it was a delay to the court system. And this is going to inject another individual in a delay to the court system. And mind you, the arguments are exactly the same. These are the arguments that were made before the Supreme Court. It's going to be deemed unconstitutional. If we want to get this done, then we need to have a change to our Constitution, Mr. Chairman, I would argue. And I'll be happy to propose it. I propose it every year to give the General Assembly the authority to do this and perhaps even give the executive branch the authority to do this. But it's already been argued. This has been the exact same thing before our Supreme Court. It was determined to be unconstitutional. And I would do everything to help patients get expedited care if someone's been wronged and be able to get that more quickly for them. I'm all for it. But this has already been before our courts. And if it's deemed to be a delay for somebody to have access to the courts, which this arguably would be as well, it's going to be found to be unconstitutional. I would have to say we have to change our Constitution to be able to get that done.
Senator Alvarado, I just briefly want to touch on your question, and I take your question. There's a significant distinction between the legislation that you're referencing that was struck down as unconstitutional and the workers' compensation laws in the state of Kentucky and the rights thereunder. The first piece is that the Supreme Court of the state of Kentucky found I believe it's the Medical Review Panels Act unconstitutional unconstitutional because it infringed on separate constitutional rights or jural rights of individuals in the state of Kentucky, specifically found under Section 14 of the Kentucky Constitution. Workers' compensation rights are created in statute, not in the Constitution. I think that's a significant distinction here, and why ultimately this regulation would be found constitutional.
It wouldn't.
Mr. Chair, this is Senator David Yates. I'll just interject whenever there's a moment.
Yes, sir. Go right ahead, sir.
Thank you. First of all, I appreciate the discussion, and I think that Mr. Flynn did touch on as far as the distinction in constitutional compared to legislative, but even just a very basic, Kentucky for a long time, we found that it was important that workers or injured people receive quick and efficient treatment. And that's one of the reasons that we're a no-fault state, so that regardless of fault in car wrecks under the Basic Reparational Benefits Act, that we found that we want to make sure people get treatment right away. Under workers' comp, I think that the necessity of making sure that workers are not turned down or denied necessary medical treatment obviously is an important thing for the Commonwealth of Kentucky. And so it makes sense why we would want a medical director to be able to do that, because in the event that they are denied, then you do go through that long litigation process. The difference between this and a medical negligence case or medical malpractice case is the medical malpractice case. When you're going in there, you're looking at damages. You're looking in to try to get a case of damages. It's not like at this point, the medical director would really be for the point of making sure there's treatment. You'd still go through the same process in the workers' comp to get damages, but that wouldn't be infringed or changed. I think you're comparing one as a gatekeeper for you receiving medical damage compensation, and the other is just to making sure that you're getting appropriate treatment. And I think that that's the distinguish that we draw and above and beyond the difference between constitutional protections and that just made by the legislature. Thank you.
Thank you, Senator Yates. Mr. O'Daniel, you have been very patient. We have had quite a lengthy discussion on this, and so I'm going to give you considerable leeway. If you would like to make some comments at this time, please first identify yourself, and then you may proceed, please.
Thank you, sir. Ed O'Daniel. I'm representing American Property Casualty Insurance Association.
Thank you, Mr. O'Daniel. Go right ahead, sir.
Thank you. First, the Kentucky Department of Workers' Claims, have long said, may be the best Department of Workers' Claims in the country. We have exceedingly well-qualified ALJs. We have an administrative staff that does superb work. And second, in 2018, the General Assembly enacted legislation that makes Kentucky's workers' comp program better. Workers' comp is about $1 billion program in Kentucky. And that program exists for two purposes. It exists to replace lost wages for injured workers or people with occupational diseases. That's first. And second, it exists to pay for the medical expenses for treating injuries or occupational diseases. We've had improvements on both of those two sides of the scale in recent years. Now, about 55% of every benefit dollar goes to pay the medical portion of workers' comp, and about 45% goes to pay for wage replacement. And both sides of that scale have improved in recent years, and in large part because of the 2018 legislation. An important feature of the 2018 legislation, as has been discussed here, is the new treatment guidelines and the pharmaceutical formulary. As the commissioner said, the department took about 2 years to get those mechanisms in place. They're in place, they're working well. we have a concern that this regulation, the way it's structured, could run afoul of the statutory requirement that the treatment guidelines be followed. This could lead to unnecessary costs for medical treatment. It could lead for treatment provisions that aren't allowed under the treatment guidelines in the statutory scheme that the General Assembly has enacted. There's a major change in how UR gets administered in this new regulation. Now, the threshold for a UR case is medical costs of at least $3,000 for an injury. And in the new regulation, this cost threshold would drop to $1,000. This is going to increase substantially the number of cases that are going to be subject to UR. I don't know exactly what the numbers are now for UR, but in the a cost of $400 imposed for each appeal, and the department projects that the revenue generated by this $400 would be $400,000 total for a year. So that indicates that there are about 1,000 cases in UR currently. If the threshold medical requirement is dropped to 1,000, there's going to be a big increase in the number of UR cases. And if there's a backlog now, I sure have a big concern that this change isn't going to help the backlog. It's going to make it worse. Another change in the regulation that's going to increase the need for UR. Now, UR applies after an employee has been off from work for 30 days. In the new reg, UR applies after 15 days. So this is another factor increasing the number of cases that are going to be going to go to on appeal. And under the new regulation, every one of these cases, it says, has got to be decided by the medical director himself. And APCIA doesn't oppose having a medical director. As Commissioner said, there are 12 states now that have a medical director. It's my understanding that none of the medical directors in any of these states personally handle all of these appeals. This medical director is going to have to be superhuman to be able to deal with all these cases and at the same time improve the delivery of treatment. And I agree with what's been said by the department. If there's a treatment backlog, we need to deal with it. But it seems to me that we're dealing with it in the wrong way. It seems to me we need to deal with it by increasing the amount of the number of medical doctors that are available, maybe add an ALJ to try to handle more of these UR appeals. the medical director, in the qualifications for the medical director in the new reg is that he be a Kentucky certified physician. There's no requirement of particular qualifications related to workers' comp. We believe that this amendment, this regulation needs to be changed to specify what the qualifications of the medical director need to be in relation to dealing with workers' comp. You know, should have some experience in dealing with workers' comp. As Senator Alvarado pointed out, this is direct use of physicians to decide on medical treatment. And that's not new. That provision is already in the UR regulation. And that UR reg that we're now operating under has been in effect, I believe, since 1995, virtually unchanged. And it's my understanding that the current UR reg works well. It can be improved. Most any of our agency operations can be improved. Even the Department of Workers' Claims can be improved. But I'm afraid what we're seeing here is not a fix. It's not an improvement. It has the potential for significantly increasing the cost to employers. It has the potential for statutory violation. The provision in KRS 342.035 on treatment guidelines, because the way I understand the reading of the regulation, this can lead to treatment things that are outside of the treatment guidelines.
Mr. O'Daniel, I have given you 10 minutes, sir, and if you wouldn't mind, I'll give you 2 more minutes. Could you kind of just wrap up, and we do have more things on our agenda.
Thanks.
I'm sorry to cut you off there, but take a couple more minutes if you don't mind, and please wrap up. Thank you, sir.
Thank you, Senator. I'm right at the end. I would simply say in conclusion, I would suggest that there be a pause in the progress of this regulation, and that all sides be allowed to make their points with the department and try to make changes that will
Mr. O'Daniel, I think we lost you there for just a moment. Are you still with us?
I hope so.
Yes, sir. Now you are. Just please conclude if you can, sir.
I think I'm done. Thanks very much.
Thank you, sir. Appreciate that, and certainly wanted to give you plenty of ample time to respond. Do we have any other questions for anyone or to any of the individuals from any of the members before we proceed on? Senator West has a follow-up question.
Thank you, Mr. Chairman. Yeah, this question is for the cabinet. Do you know, has this regulation been proposed or this idea been floated in any other legislative committee hearing? Do you know?
I do not believe it has.
Okay, thank you.
Not that I'm aware, Senator.
Okay, thank you. Once again, I just want to reiterate, I really, truly appreciate the cabinet agreeing to defer and allowing us to use this committee meeting as an information-only meeting. I truly understand both sides on this issue. I understand the goals of the cabinet is to protect injured workers. There's no doubt that's a very important role and goal as well. I got 3 problems personally with this reg, and I just want to lay those out there with the idea that, you know, maybe we can come to an agreement at some point on this reg, but the idea of a medical director actively seeking new claimants after a doctor has said there is no claim, that tells me we're going to have a lot of new workers' comp claims because invariably a client who has been told by a doctor he or she has no claim, who gets a call from the medical director stating, you know, you could push this a little further. Clearly, that's going to increase workers' comp claims that may have not otherwise been there. And I'm an attorney, and with the Kentucky Bar Association, we have ethics rules and guidelines that prohibit the solicitation of clients. So sometimes in those cases, attorneys in this state would be prohibited from doing that. Secondly, the decision-making seems to be a consolidation into one individual rather than a multitude of ALJ judges. And to me, this could cause a serious swing in rulings in Kentucky. So with a multitude of ALJ judges, it's like a shotgun approach. You've got some balancing there. With one medical director, he or she would bring in their own philosophy, and you could have swings and rulings depending on who's governor. So you have one person who's appointed who hangs over here on the side of injured workers to an extreme, and you have one medical director that maybe hangs over here on the side of protecting the insurance companies or something of that nature. And you could have a medical director, hopefully you would have a medical director that was right in the middle, but that's highly unlikely. So at the very least, my third problem is this is a huge change in the way we do business that has not been vetted or approved by the General Assembly. So there's been little to no input on this from the General Assembly up to this point. So those are my problems. Not saying we can't get over those. That's what we have. That's why we have these meetings. But just wanted to lay that on the table. Thank you, Mr. Chairman.
Thank you, sir. Having had some very good, lively discussion, I would like to certainly thank the members of the cabinet again for deferring this specific regulation. But we have had some good discussion on it today, and thank all of those individuals. And Mr. O'Daniel, thank you for your time, sir, and some very good questions presented to us today. Being no further questions, please call the next regulation at this time.
Public Protection Cabinet, Department of Insurance, 806 KAR 4010, 9025, 12120, 13150, 17070, 085, 100, 150, 230, 260, 290, 370, 450, 511, and 806 KAR 46050, all with staff suggested amendments.
This package of administrative regulations updates material incorporated by reference and makes technical and other changes to comply with KRS Chapter 13A. Additionally, 806 KR 4010 adds and removes various fees. 806 KR 9025 and 12120 make changes to align with the National Association of Insurance Commissioners model regulation relating to annuity training. 806 KR 1770 adds cancer and critical illness policies and indemnity and lump sum benefits to the types of benefits recognized. 806 KR 1785 establishes standards for extension of benefits, discontinuance and reemplacement, reinstatement, benefit triggers, inflation protection, home health, and community care benefits within short-term nursing insurance policies, advertising, and disclosures. 806 KR 17150 requires forms to be submitted electronically using the system for electronic rate and form filing, removes requirements relating to basic health benefit plans, updates market segments, removes requirements for the actuarial memorandum to discuss the effects of certain state-mandated benefits, and removes requirements related to the Guaranteed Acceptance Program. 806 KR 17260 makes changes relating to conversion policy minimum benefits. 806 KR 17290 makes changes relating to the Independent External Review Program. And 806 KR 17511 repeals various administrative regulations. The staff amendments for this package of regulations all make changes for clarity and to comply with KRS Chapter 13A. Additionally, the staff amendments for 806 KR 410, 13150, and 1785 amend various sections for statutory compliance. 806 KR 17511 amends to delete the repealer in the regulation of 806 KR 175 and 17180.
Would you please identify yourself today, whoever is joining us this afternoon?
Yes, good afternoon, Chairman. My name is Abigail Gall. I'm the Regulations Coordinator here at the Department of Insurance. Our General Counsel right here, Chad Thompson.
Good afternoon.
And I'm Commissioner Sharon Clark.
Thank you all today for being with us. We appreciate your time. A lot of regulations, specific regulations that were presented to us or given to us. There are staff amendments to these regulations. Is there a motion for the approval of the staff amendments? There is a motion, and there is a second? Without objection, it's so ordered. Do we have any questions from the members? Senator West has a question. Go ahead, sir.
I'm just full of questions today, Mr. Chair.
Right ahead. Thank you.
This is for my information, not necessarily anything relating to these regs, but in KAR 806 KAR 4010, where we talk about PBM fees, $1,000. Do you happen to know how many PBMs we have operating in Kentucky?
Not off the top of my head. Thank you for that question, by the way. I can find out.
Senator West, let me step right outside the door and I'll get an answer for you and be right back.
Okay. That's actually a question for another committee, but
yeah, no problem.
You can get that to the committee later if you need be, and that's my only question.
Okay.
Thank you.
Thank you.
Any further questions from any of the members of the committee? If you could just get the answer to that question that Senator West asked, and you could just send that to the staff and they could pass that on to us, we would appreciate that very much.
Yes, of course. Thank you all.
All right. Thank you very much. There being no further questions, please call the next regulation.
Thank you.
Cabinet for Health and Family Services, Department for Medicaid Services, 907 KAR 3005, 010, and 060. 010 has a staff suggested amendment.
907 KR 3005 amends to remove medical direction of anesthesia service from coverage limitations. 907 KR 3010 amends to establish the method of reimbursement for physician services by the Medicaid program. Establish the definition for anesthesia under medical direction. Update the web location for the Medicaid physician fee schedule. Remove language requiring reimbursement for anesthesia with a modifier. Establish requirements for anesthesia under medical direction to be eligible for reimbursement and that documentation is required for all services. And establish what does not qualify as anesthesia under medical direction. The amended after comments version deletes previously added language in Section 8 for anesthesia under medical direction and requires instead compliance with the Medicare Claims Processing Manual. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
907-3060 establishes the ambulance provider assessment for ground ambulance providers in accordance with 2020 House Bill 8.
Whomever is joining us from the cabinet today, would you please at this time identify yourself for the record?
Good afternoon. I'm Jonathan Scott. I'm the Regulatory and Legislative Advisor for DMS.
Thank you, Mr. Scott. Anyone else? Is that all? All right. There is a staff amendment to this regulation. Is there a motion for approval, please? Motion has been made and it has been seconded without objection. It is so ordered. Are there any questions from any of the members of this subcommittee for Mr. Scott? It appears there are no questions. Mr. Scott, thank you for being with us today. Please call the next regulation at this time.
Continuing under Cabinet for Health and Family Services, under Department for Community-Based Services, 921 KAR 1020, 390, 400 Emergency, Chapter 2, 015 Emergency, Chapter 3, 027, and Chapter 4, 116 Emergency. Both 921 1020 and 390 have staff suggested amendments.
921 1020 amends provisions for child support enforcement to make technical corrections and update material incorporated by reference. The staff suggested amendment amends various sections to comply with KRS Chapter 13A. 921 1390 amends provisions for paternity verification related to child support to make technical corrections and delete the fee and form for the cabinet to receive a fee for genetic testing. The staff suggested amendment amends various sections to comply with KRS Chapter 13A. 921 1400 emergency amends provisions for child support and medical support orders to make technical corrections and update material incorporated by reference.
921 2015 emergency amends to increase the reimbursement rate for personal care homes in accordance with 2021 House Bill 192 and establish the standard of need annual cost of living adjustment.
921 3027 establishes SNAP requirements in a new regulation because the old regulation 921 KAR 3025 was nullified by Senate Bill 65 in the 2021 regular session. The companion emergency to this regulation was reviewed at the August ARRS meeting. 921 KAR 4116E amends to delete the requirement that air conditioning units provided through the program be window units only and increase the program cooling component benefits in Section 4, Subsection 2 due to a federal funding award increase in Low-Income Home Energy Assistance Program block grant funds.
Would you identify yourself for the record, please, at this time?
Good afternoon. My name is Laura Beacon. I'm with the Department for Community-Based Services, and I am representing the last three administrative regulations mentioned in Title 921. I know someone's on for child support enforcement for the first three.
Do we have someone else that's joining us, please?
Yes, I'm Steve Vino, Commissioner, Department for Income Support.
I am Lily Pattison. I'm the Child Support Enforcement Director under the Department of Income Support.
All right, thank you very much for being with us, all three of you, this afternoon. There are staff amendments to these specific regulations. Is there a motion for approval of these staff amendments? There has been a motion. Is there a second?
Second.
There is a motion and a second. Without objection, it is so ordered. Are there any questions from the members of the subcommittee for either of the individuals that's with us today? There appears to be no questions, so we appreciate your time and thank you for being with us today. Do we have any more regulations?
That concludes our agenda for today. It looks like our next meeting would be Tuesday, October 12th, which is the traditional second Tuesday of the month, and that would be at 1 p.m.
Thank you. Everyone take note of that, Tuesday, October the 12th. I would just like to say to all the members, thank you today. A rather lengthy meeting. Appreciate the questions. Senator Alvarado, you joined us in our last meeting, which was kind of an emergency called meeting. But again, we just want to take the opportunity to welcome you to our committee today. And we appreciate that, and all the other members that are with us today. Thank you for being with us. Have a good afternoon, and the meeting is adjourned.